Hey everyone, my name is Roy Jacobs, an attorney with Cape Fear Family Law, here to talk to you today about the Paynich v. Vestal case out of the Court of Appeals. This is a case originating out of Buncombe County from a custody order from Judge Dray and handed down in the Court of Appeals this January of 2020. So a little background on this case. The parties were married for 15 years, married in 1997. They had the minor child at issue in 2011 and separated a year later. From the outset of the case, it was a high conflict case. The court had to appoint a parenting coordinator. The parties actually did share custody of the minor child until an emergency custody order was entered that ordered a parenting evaluation for mom and gave sole custody of the minor child to dad. The parties had their permanent custody hearing later in 2015, where the mom was given supervised visitation and dad maintained sole custody of the minor child. In 2015, the parties had their permanent custody hearing where dad was given sole custody of the minor child, with mom getting only supervised visitation. In 2016, the court ordered her visitation be expanded to allow for unsupervised visits. And in 2018, mom was actually awarded a mixture of both supervised visits and unsupervised visits. And that's where this case is coming. It's from that custody order that mom appealed, and this case covers two issues. Mom being given supervised visitation without a finding that she was an unfit parent, and mom not being allowed access to medical, dental, and educational records for the minor child. In order for the court to deprive a parent of visitation, there must be a finding that either the parent is unfit or that the visitation is not in the best interest of the minor child. Supervised visitation itself is considered a severe restriction on parental rights. So in order for someone to be ordered to have supervised visitation only of their child, there must be specific findings of facts showing that it's either not in the best interest of the child or that the parent is unfit. This case was strange because mom had both supervised and unsupervised visits. What the Court of Appeals found was that the decision to give mom supervised visitation was supported by specific findings of fact. What the trial court specifically found was that there was a causal link between some of mom's behaviors, which were odd, to say the least, and behaviors exhibited in the minor child, which included more frequent soiling themselves after being in mom's care and more aggressive behavior. There's a long list of odd instances of mom's behavior, but just to recap a few: mom vandalized dad's car at exchanges. She got into arguments in front of the minor child at pickups at school. There was an incident where mom dropped the minor child off at dad's house instead of the agreed upon exchange point and left the minor child there all alone. There was also weird behavior concerning their time together, where mom would play a game that involved tickling the minor child until they soiled themselves. So the key on this issue is that if a parent is going to be giving supervised visitation, there has to be findings of fact supporting that they are either unfit or that unsupervised visitation is not in the minor child's best interests. So mom did not win on this issue. The issue mom in this case did win on was the denial of her access to the minor child's medical, dental, and school records. The court relied heavily on the case Hummel v. Hummel. That was a case where the dad was denied access to records. The case is different than this one because in that case, dad had had such poor interactions with a host of third parties, including schools and counselors, that it made them feel so unsafe that it actually stopped them from wanting to work with the mom in that case. This case was different from the Hummel case because a counselor had actually told the people who worked at the minor child's school that they actually weren't in danger or anything like that. So she was just banned physically from being on the school's campus, but that didn't mean she couldn't have access to getting this kid's educational records over the phone. So she won on that issue and was able to get access to her kid's school records. So this case ended up being affirmed on the mixed supervised and unsupervised visitation issue and reversed on the issue of denying access to records for the minor child. So if you enjoyed this video, please like and subscribe to all of Cape Fear Family Law's content and tell us about what issues you might be having as far as custody and visitation.